Dr. Reiner Fuellmich was sentenced to 3 years and 9 months in prison, with 5 months of pretrial detention not being credited. Thus, the severe prison sentence announced by the court at the beginning of the trial has been confirmed. The announcement came unexpectedly, late in the evening, as Dr. Fuellmich had just given his final statement and several more trial days were scheduled. The charge of embezzlement in 2 cases was clear to the court from the beginning. Established. The assets of the non-profit entrepreneurial company Foundation, Corona Committee Preliminary Geogen Foundation, were embezzled through his actions. The defendant's argument that a private loan means I can use the loan privately, period, was not accepted by the court. However, neither the willingness to repay nor a possible agreement from the co-shareholder Vivian Fischer was decisive. Because even if this had been assumed in favor of the defendant, the chairman stated, the Articles of Association stipulate that the shareholders should not receive any benefits. The court did not accept the argument that the Corona investigator wanted to protect the company's assets from state seizure by offering his property as repayment security, as one could have defended against unlawful seizures by the state using the state's own legal means. In his final statement, the system critic, who has relinquished his legal license, gave a legal lecture on the offense of breach of trust and the dangers of its misuse. The liquidity crisis is pure show. A sham contract agreement was invented to get rid of the loan agreements. Civil law was also pushed aside with the aim of prosecuting a Corona critic criminally, according to the defendant. To meet the accusation of the very flexible offense of breach of trust under paragraph 266 of the German Criminal Code, one would have had to consider all decision-relevant circumstances and the behavior of all parties involved in the overall assessment according to Dr. Reiner Fuellmich. The investigative work as a decisive performance criterion was ensured at all times, as he, together with Vivian Fischer, continuously conducted investigations, even internationally. The existing earmarking of donations from donors in this regard, or donors, was therefore always ensured according to him. Dr. Fuellmich admitted his mistake of trusting the wrong people when he wanted to establish a foundation with the former co-partners of Forschalt Gog, the current complainants, which never reached registration in the commercial register due to the lack of recognition of non-profit status by the tax office, which was a prerequisite for the formation of the corporation. The court sees it differently, believing that no damage could have occurred from the defense's perspective. Not only do diametrically opposed legal opinions regarding civil law questions about donations or gifts meet in this case, but the court and the defendant also fought each other to the utmost. The defendant even accused the court of abduction. The denial of the right to be heard before the conclusion of investigations, lack of investigations that could have contributed to his exoneration, white torture in custody, incomplete files, shortening of the evidence-taking process, ordering of written proceedings, restriction of the defense's questioning of witnesses, and thus judicial misconduct. The court, on the other hand, accused the defendant's defense of abuse of rights. Instead of convincing the chamber of their legal opinion, a coordinated process behavior with the defendant was used to provide both the defendant and the defense a platform to influence the public and spread the defendant's political messages to Fuellmich supporters. Additionally, adventurous stories were spread by Dr. Miseries has been spread. For example, that the chamber had a mandate to convict and that the Office for the Protection of the Constitution was behind the proceedings. The very last word was had by the majority of the spectators and trial observers present, who expressed their dissatisfaction with the verdict after it was announced, by stating that it was not made in our name. No, that's not true. The mainstream press, which was absent during the verdict and almost all trial days, indulged in sensational headlines to report on the so-called lateral thinker lawyer and his conviction. Here are some headlines. Corona denier, who during the Corona pandemic with the Foundation, Corona Committee, deliberately spread misinformation. Corona enlightener, in quotes mind you. Lateral thinker lawyer, I leave it to your own judgment to decide whether this is a politically motivated trial or not.
They want to keep me here for a few more years.
They won't manage that, Reiner.